And honestly, as I read the case, 42 pages, that's what an ownership attorney does. I go in, I make sure I stay on top of cases that deal with business entities, intellectual property, all that good stuff. So as I read this case, for me, in my analysis, I'm listening to what the judge is saying. I'm listening to how the judge is using certain things to make its ruling. And it sounds like to me, if other courts, because trust me, FinCEN, they're going to appeal. They're going to appeal this. But if other judges read what this judge has said, this is called precedent. They look at other court cases as well. I think it's going to be a tough one. I do think it's a tough one to overcome that constitutionality barrier. And why do I say that? Because there are certain powers that's invested, right, within Congress. And the judge in this particular court case really drilled down on that and said, okay, you have certain powers that's invested in you in order for you to do whatever. You have the powers for interstate commerce, and they also have a power called necessary and proper clause. Interstate commerce just means you have the power to overlook businesses moving goods and services throughout the states. You also have the power that if it's not written in the Constitution, you also have the power through the necessary and proper clause to create certain legislations that are aligned with the powers you do have vested, if that makes sense. As the judge looked at everything, FinCEN, the BOI, it does not align with interstate commerce. Why doesn't it align with interstate commerce, you might ask? Because you're looking at businesses. Why doesn't it? Because if you read the regulations or the legislations of the BOI, it says, of CTA, it says, if you formed a business entity in the U.S. or if you're a foreign entity and you're doing business in the U.S., and you have filed to do such, then you have to report. It doesn't say you're necessarily doing business. It just says if you filed or formed an entity. Some of us form entities as holding companies. Doesn't necessarily do business. Some form entities to hold real estate. Doesn't necessarily mean you're doing business. So what the judge looked at is it doesn't fit into interstate commerce because you're assuming that everyone who forms an entity is actually active or doing activity in interstate commerce, and that's not the case. So that means it's not in your jurisdiction. You don't have hooks in every business. And then secondly, they already looked at the necessary and proper clause. Remember, I told you that clause is just there to say if the powers that you need are not necessarily written in a constitution, you can do what's necessary and proper to align with those particular powers. But what the judge looked at is, again, if there's something not written, whatever you need to write, it still has to align with whatever powers that you actually have. And in this case, again, the judge said you don't have powers as of right now. What we see, you don't have powers to regulate every business. And to give you a number exact, I think they said it was like 3 million businesses, 3.6 million businesses. And they said every business is not actually active. So you cannot blanketly put this legislation in place